Judicial ethics, the topic of a recent law school's publication about, what's happening in their state and beyond. And some of our reporting on judicial ethics here in Illinois getting a footnote when talking about the problems of judicial recusal. This coming from the University of Wisconsin Law School. We'll touch on that in a moment, but just a flashback 6 months ago, if you recall, I asked Governor J.B. Pritzker about his $1 million to each of two Supreme Court justice candidates during the 2022 election, and then those justices being on the bench to decide cases that were brought forward challenging laws that Governor J.B. Pritzker signed, being the Safety Act, which was challenged, but also the gun and magazine ban that was challenged, and the recusal request from the plaintiffs there being denied by the justices in question, Elizabeth Rochford and Mary O'Brien, and by the Supreme Court in its entirety, saying they didn't have the power to keep a justice from hearing a case. So we'll touch on what this explainer from the state's Democracy Research Initiative out of the University of Wisconsin-Madison. But flashing back 6 months ago when I asked the governor about his campaign contributions to these Supreme Court justice candidates, and his response was rather fascinating, and I just wanted to re-air that for you here as we get ready to talk about this.
Explain the $1 million that you gave to each Supreme Court justices, and should they recuse themselves in two important cases coming up, Safety Act, no cash bail, and also the gun ban?
I am sure this is something that the right wing is trying to stir up. I know you've written about it. The fact of the matter is I supported candidates who are running all across the board. If you're suggesting that the fact that I gave money to, let's say, the Democratic Party or to the committees that supported candidates means that everybody who received any money has to recuse themselves from anything to do with the state of Illinois, that's ridiculous. And I've certainly never asked anybody to vote a certain way or decide on a case a certain way. I would never do that. I never have. I never will. And these are independent judges, and they didn't go around and campaign on things, that they thought would win my support for them. I believe in them. I supported them like lots of other people did. Thank you.
Again, the governor addressing the question directly, saying that to have these justices recuse themselves because he gave some political donations is, quote, ridiculous. But is it ridiculous? You've got the University of Wisconsin-Madison looking into this and having some interesting things to say about judge recusal in general. And shout out to President Non-FUD on Twitter, who found this. And it was published earlier this month, an explainer, judicial recusal in Wisconsin and beyond. And it goes through a bunch of different issues, recusals in Wisconsin, but they also look at recusals in other state and federal courts. And also looking at, for instance, here in Illinois, where you've got the recusal of the request recusal in a firearms-related litigation. So we'll go ahead and click on that just to read what they have here. So firearms-related litigation in Illinois. Illinois provides a recent example of a high-profile recusal dispute involving campaign contributions and activities. In early 2023, the state enacted an assault weapons ban that was immediately challenged in court. The matter made it to the Illinois Supreme Court, where the plaintiffs filed a motion asking two recently elected justices, Mary Kay O'Brien and Elizabeth Rochford, to recuse themselves. There's a link here to a footnote, and just to do some bragging a bit, I guess. The footnote goes to a story that I wrote for the Center Square about that motion that Dan Calkins' attorney filed to have these two justices recuse themselves, and that was way back in March of this year, if you recall. But it goes on to say, the motion highlighted large campaign contributions that each judicial justice had received from the governor and the Speaker of the House, who were named defendants in the lawsuits. Each justice's campaign had received $500,000 from the governor's campaign committee and $500,000 from the governor's personal trust. Additionally, one of the justices had received a $350,000 contribution from the Speaker's campaign committee, while the other justice received a $150,000 contribution. According to the motion, these contributions amounted to more than a third of the total campaign funds that each candidate raised. The motion also cited a joint statement from two pro-gun safety political action committees that celebrated the two justices' election victories and had suggested that the candidates indicated that they supported banning assault weapons and large-capacity magazines in Illinois. Both justices declined to recuse in separate responses. In Justice Rochford's response, she noted that the campaign contributions she received were within the state's campaign finance limits. She also addressed the plaintiff's claim that her participation would create the appearance of political influence, reasoning that such a standard would be unworkable as judges would constantly have to recuse themselves. She also cited a 2014 matter in which the Illinois Supreme Court Justice Lloyd Carmeier declined to recuse himself from a matter involving tobacco giant Philip Morris, the parent company of which had contributed $500,000 in the justice's campaign. Carmeier had written, when judges are elected, as the Illinois Constitution requires, it is inevitable and equally appropriate that interest groups will support judges whose judicial philosophy they believe are most closely aligned with their views. The system would come to a grinding halt if contributions by organizations and interest groups were sufficient to force a judge to recuse himself or herself in any case which the member of the group was a party. Members of the courts would be prevented from hearing a substantial number of cases from the entire duration of their terms. They were elected by voters to serve, and the court's ability to do its work would be compromised, Carmeier said. So the particular paper here from the Wisconsin-Madison University, Justice O'Brien's response took a similar tone, and like Justice Rochford, Justice O'Brien approvingly quoted Justice Carmeier's order declining to recuse from the Philip Morris matter, writing, "Rumor, speculation, belief, collusion, conclusion, suspicion, opinion, or similar non-factual matter are not sufficient to require recusal. A judge is as much obliged not to recuse himself when it is not called for as he's obliged to when it is." So interesting to see this. Again, you've got the issue of judge recusal and judicial ethics being highlighted in a different state by looking at Illinois in particular. And if you get an interest to look this up again, it's called Explainer, Judicial Recusal in Wisconsin and Beyond. You can go and read that and read some of the background and the findings and so forth. So interesting to see that. And of course, it's always fascinating to see how far work that I do might penetrate into other areas and how it's used as source material for ongoing investigations. So I just wanted to share that a little bit with you. By the way, no update on the Seventh Circuit Court of Appeals and their hearing of the state's gun and magazine ban. Once that happens, we'll definitely be getting that out to you so you are in the know.